Okay, let's go and hear from...
And a legislative statement on the Crimes Legislation Stalking and Harassment Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website. Honourable Paul Goldsmith.
I move that the Crimes Legislation Stalking and Harassment Amendment Bill be now read a first time, and I nominate the Justice Committee to consider the bill. Every New Zealander deserves to feel safe in their community. When a person is stalked, the experience permeates every aspect of their life. The behaviour can escalate to serious physical harm. We know the public is concerned about stalking. We've heard from advocates who tell us stalking needs to be recognised as its own offence. Today I'm very proud to present the Crimes Legislation Stalking and Harassment Amendment Bill to the House. This bill delivers on our commitment under the Q4 Action Plan to introduce legislation to address stalking by the end of the year. The bill creates a new offence of stalking and harassment. It repeals the existing offence of criminal harassment in the Harassment Act. We heard from advocates that the placement of the offence within the law is important, as it sends a clear message about its seriousness. The new offence will therefore be inserted into the Crimes Act 1961. The seriousness of the new offence will also be reflected by its penalty. A conviction of the new offence will be punishable by up to 5 years imprisonment. The offence has two key elements that will need to be satisfied to secure a conviction. First, the perpetrator will need to have engaged in a pattern of behaviour against the victim. The bill defines a pattern of behaviour as 3 specified acts within a 12-month period. Secondly, the perpetrator needs to have engaged in that pattern of behaviour knowing it was likely to cause fear or distress to the victim. The bill provides a list of the types of behaviours that may be a specified act. These include things like watching or loitering near the victim, tracking or communicating with the victim, and damaging or interfering with their property. It also includes less tangible harm like damaging or undermining the victim's reputation or relationships. We've heard that stalkers often use other people, organisations and institutions to stalk their victims. Examples of these behaviours and the harm it can cause have also been documented in the media recently. To address this bill provides that specified acts may be done directly or indirectly to the victim. This makes it clear acts may be done through or to a third party with the knowledge that it will cause the victim fear or distress. The bill also makes it clear that a specified act can be done by or through any means or whatsoever. Examples of different means are given, such as the use of tracking devices, spyware and artificial intelligence. These clarifications seek to future-proof the law by ensuring that new forms of stalking can still be captured by the law. To protect legitimate conduct from being criminalised, a defence to the offence is included in the bill. Specifically, it provides that a defendant will not be liable for behaviour done for a lawful purpose, with a reasonable excuse, or in the public interest. This ensures that, for example, law enforcement can perform its function without the risk of persecution or prosecution. As part of the offence, the bill establishes a police notification system. This allows the police to notify stalkers that their behaviour is causing the victim fear or distress, and that if the behaviour continues, they are liable to be charged with the offence. A police notification is not required to prosecute the offence. Receiving a notice will not be a prerequisite for filing a charge, but a notice should not be given instead of prosecution where it is clear an offence has been committed. However, where a notice is given, a notification system will support prosecution. So if a person has previously received a notification and they continue to engage in a pattern of behaviour, the bill creates a presumption that they knew their pattern of behaviour was likely to cause the victim fear or distress. This assists in proving the mental element of the offence. The notification system makes it clear that there are real consequences for stalkers. It also aims to reduce the steps victims need to go through to have their harm responded to. In addition to the new offence, the bill makes supporting amendments to 4 other acts to address stalking. Amendments to the Sentencing Act 2002 aim to better recognise the unique characteristics of stalking and provide better protection for victims. The bill will add 2 new sentencing aggravating factors. First, it will be an aggravating factor if the offending took place where the victim had a restraining order against the offender. Secondly, it will be an aggravating factor if the offender's behaviour towards the victim outside of the offence involved persistent or repetitive behaviour over a prolonged period. That behaviour must have caused or likely to have caused fear or distress in the victim. The bill also allows the court to make new orders when sentencing a person convicted of the new offence. Specifically, the court will be able to make restraining orders under the Harassment Act 1997 and orders under the Harmful Digital Communications Act 2015. This change provides additional protection for victims of stalking, meaning that they won't also have to seek civil remedies alongside a criminal trial. The bill amends the Family Violence Act 2018 to make it clear that stalking can be a form of family violence. Psychological abuse already captures intimidation and harassment, so this change provides consistency and completeness. The evidence indicates that stalkers with access to firearms are more likely to escalate to violence. To address this risk, the bill amends the Arms Act 1983. That amendment provides that a person convicted of a new offence within the last 10 years will be disqualified from holding a firearms licence. Finally, the bill makes changes to the Evidence Act 2006 to prevent a defendant charged with a new offence from personally cross-examining the alleged victim. This amendment aims to reduce the risk of witness intimidation, reflecting the particular nature of stalking cases. I'm proud to bring this bill to the House today, which brings real consequences for stalkers and better responses for victims of stalking. I want to thank the tireless work of the advocates in this space for their continued efforts. I want to acknowledge the more than 18,800 people who signed the Coalition for the Safety of Women and Children's petition to make stalking illegal. We hear you. We're now sending off for a full select committee process where we're happy to discuss the finer details. And I'm sure people will have many things to say about that, and we're very keen to hear those comments. We're delivering on our commitment, Madam Speaker, to ensure that there are 20,000 fewer victims of serious violent crime by 2029. And this bill brings us one step closer to this commitment. I hope that we will enjoy widespread across the House for this important legislation. I commend this bill to the House.
Yeah, good bill. Nothing here to hate. So just some commentary. Stalking is currently treated as a form of harassment in New Zealand, and harassment that causes fear for their own safety or the safety of a family member can result in a 2-year sentence. Obtaining statistics for stalking is really difficult because the police tend to combine stalking data with abduction numbers and other related offences against a person.
So that muddies the water quite a fair bit.
Correct. And having stalking as its own criminal offence will definitely provide clarity. I was able to find some numbers thanks to the Herald, which they managed to obtain under the Official Information Act. They found that reports of criminal harassment have more than doubled in the past 5 years. So from January to September in 2022, there were about 1,250 reports that were filed. So, yeah, it's definitely a problem here in New Zealand, and having it as a separate criminal offence will definitely help with the statistics, at least providing a lot more clarity.
Yeah, I definitely know the feeling of it. Now, the one thing that I think will need to be and may have to be done at Select Committee is the use of the anonymous allegation lines, primarily the WINS one, but also possibly the IRD one, is that WINS are known for covering up breaches of protection orders on that line. To say, but we've got to guarantee them anonymity. Well, they shouldn't be given anonymity if they're breaching a protection order, because you lose the right to anonymity when you're committing a crime to cause that harm. And that's something that needs to be done on there, because I know when I fled Kandala, James was things that were threatening in there, and some of the things were ringing the IRD to get me in the ship with the tax department, and some of them were threatening to play around with my disability allowance, equating it to the supported living payment benefit, which is a complete misunderstanding. Now, IRD probably would sit there and take what he says with grain of salt. Working Income would sit down there and take it with full force as he's telling the whole truth, nothing but the truth, so help me God. He's an abuser, and we'll back the abuser before we back the abuse every single time. Yeah, something that Mr. Alex has brought up was could the stalking bill cover nuisance streamers as well? As recently in South Korea held a nuisance streamer called Johnny Somali for defacing a statue in South Korea. Who knows? I
was looking at the bill. There is something that allows for restraining orders under the Harassment Act of 1907 and orders under the Harmful Digital Communications Act of 2015 to be made sentencing when sentencing a person convicted of a new offence. So, yeah, it seems that digital or cyber harassment's also been taken into
account. That's a good thing.